This is Michael Popok. Look at the time. Look at my glasses. It must be Legal AF after dark. And now we've reached that point where in the Legal AF podcast, we got to talk about the Jan 6th insurrectionists and the Department of Justice gearing up again to go after them for interference and obstruction of an official proceeding. In this case, their attempts to overthrow democracy by attacking and burning the Capitol and trying to stop the certification of the election. Did you really think the Department of Justice was going to take this lying down, that they weren't going to try to revive the counts related to obstruction of justice based on the MAGA right alt-wing court, Supreme Court, and its ruling that said, well, if you don't have fake evidence or false evidence, then you really can't have obstruction of an official proceeding? We have fake evidence. We have false evidence. We have obstruction of the actual certificates. And that's how the Department of Justice is going to go after these Jan 6 insurrectionists all over again. And we cover it on the MeidasTouch network and on Legal AF. Take a listen.
But also more broadly, you have the Department of Justice having to address the issues now raised by the other Supreme Court ruling, where the Supreme Court narrowed the obstruction of official proceeding charge so that it has to relate to obstructing official proceedings in connection with the destruction of documents themselves, even though when we analyze the statute, it clearly said, or obstruct or otherwise obstruct an official proceeding. And January 6th was an official proceeding. There was a subsection A and a B. A subsection A involved destruction of documents, and the Supreme Court ultimately ruled that you have to read A and B, subsection A and subsection B together, even though it had an or, which to me means or, but that's not how the Supreme Court read it. So in any event, the Department of Justice has had to make filings and status reports to let the various federal judges know how are they going to treat cases where individuals, insurrectionists, were charged with obstruction of an official proceeding. So in a filing yesterday, the Department of Justice said that since the Supreme Court's Fischer ruling, it dropped 18 USC 1512 C2, that's the obstruction of official proceeding statute charges, in 60 cases. So far, it's elected to pursue 1512 C2 in 5 cases. And in the cases where it dropped 1512 C2, it often added a new charge as well to ensure that these very violent people are not like getting out. There's other charges that could be brought that just may be a little more of a pain in the neck to prove at trial, just at a technical level. But there's going to be a case-by-case review that will be happening. And then specifically in a brief that was filed, United States of America versus Shondell Chilcote and Donald Chilcote. This is an example of one of these briefs that the Department of Justice filed. It says, the United States, through the undersigned counsel, files this status report describing its view of the impact of the Fischer decision by the Supreme Court on count 1 of a superseding indictment, which charges the criminal defendant with 18 U.S.C. section 1512 C2. As discussed below, Fischer does not bar this prosecution. To be sure, Fischer will require an updated jury instruction regarding the elements of a violation of 1512 C2 and below. The government proposes such language, but the government expects that its evidence of the defendant's conduct and the inferences to be drawn from that conduct will be sufficient to submit this case to the jury and sustain a conviction. At this time, the government intends to proceed to trial on count 1 on the superseding indictment. So this, Michael Popok, is how we're able to predict things that will happen in other cases, specifically what's going to happen at that September 5th hearing before Judge Chutkan. So one of the reasons, right, that Jack Smith asked for a brief delay, I think, is so that the entire Department of Justice machinery can get on the same page. So there's not inconsistent pleadings, right? And now what we're seeing is the DOJ rolling out its 1512 C2 position. And now Jack Smith will be giving his 1512 C2 position, as well as the absolute immunity ruling, how that figures into it. And I think Jack Smith will have a very nuanced, careful, and specific view about the case against Donald Trump will proceed. Here's how we intend to deal with the Supreme Court's ruling. maybe they're going to have to introduce another indictment, a new superseding indictment that removes allegations. But that is my expectation there. But, for a lot of these insurrectionists who thought, oh, the Fischer decision, now I can't be charged with obstruction of official proceeding, the Department of Justice is saying, no, we're still going to charge a lot of these cases. Some we're going to drop just that count. It's not like the insurrectionists are getting off. They've been charged with other stuff already that they've pled to, just that count. They now may be charged with other stuff. And they say, you know what, there are some cases that there's evidence that this was about blocking the certification documents, and therefore it's a document case. And if it's a document case and a destruction of documents. But Popok, what do you think? What do you think there? And then we'll talk briefly also about New York Attorney General Letitia James filing.
Yeah, there's 24 people that were only charged with 1512 of the Jan 6 insurrectionists, and all of them, if they took plea deals, which most of them did, have a provision in their plea deal that says if this 1512 gets vacated in some way by a future Supreme Court decision, because the Department of Justice is really smart, and they anticipate bad things happening at the Supreme Court level, which we all do. It has an automatic trigger inside of the plea deal that says if this 1512 goes by the wayside for some reason, then we'll be able to indict you for other crimes. And there's other crimes that they could have indicted them for and will indict them for, but it only really relates to a very small subset of people, because almost all the Jan 6 defendants that were charged with 1512 obstruction of an official proceeding were also charged with other felonies carrying very similar sentences. And we anticipated this. Look, I did a hot take on it 6 months ago. So did you. We talked about how prepared they were going to be, why they've gone inside, as you said, the beehive of the Department of Justice, and they've had to think through all of this current band of Jan 6 insurrectionists, the future Jan 6 insurrectionists or people like them, how it impacts Donald Trump. And so there were a lot of department heads that were sitting around a table, electronically or otherwise, having to weigh in, because this was like a 12-level chess match, and the law of unintended consequences they were trying to avoid, and making sure they didn't take a bad position here that could impact these other cases. The way forward was inside of the actual Fischer decision. Page 8 of the Fischer decision is in the majority decision, obviously fought for and placed there by Sotomayor, who joined in that decision, or actually was in the dissent, but got a part of it. I think impacted a part of the ultimate decision. Cited a case of hers back when she was on the Second Circuit in New York before she became a Supreme Court justice, in which false evidence, the use of false evidence and false documents, could be a way to prove that particular 1512 violation. And with Trump, it's easy, because the false certificates, the fake elector certificates that they wanted to use to throw out and trash the real ones and count those instead, to throw the entire thing over to the House to let them pick the president, like we were in the 1880s or 1870s, the old-timey time. That's the false evidence we're talking about. And then it also gave the blueprint, as you pointed to, for the Department of Justice, if they think they need it, to re-indict and to add particular elements, if it fits, for people trying to get their hands on the certificates. Because if they were trying to get their hands on the certificates to stop the certification, and it rises to the level of either destruction or obstruction of those documents, or as I said, these false evidence, I think you'll get them. But the good news is, in a belt, suspenders way, the Department of Justice always indicted these people for multiple things. And so even if 1512 fell by the wayside, these people are going to jail for a long time, and they're going to be re-indicted for things now that they're, like you said, there's no hooray, 1512's out, Mr. Fischer. Yeah, Mr. Fischer too, by the way. Mr. Fischer, who's the named appellant in the case, can have his plea deal or his conviction, and now they can just go right back at him for something else. And there's plenty of time to do that, and it's not double jeopardy. So I agree with you. I think that the 3 weeks, they had already spent over a month, the Department of Justice and Jack Smith, getting ready for what position they were going to take with Chutkin, but it was complicated and they needed more time and they asked for more time. It also reinforces something that Judge Cannon can't get through her thick judicial skull, which is that the special counsel is an inferior officer and an employee of the Department of Justice. He doesn't get a 1099. He's not an independent contractor. He works for somebody. He has a boss. The boss's name is the Attorney General, and he has to report into the Attorney General, and he has to, as part of the actual provision that gives him life, the special counsel provision of the Code of Federal Regulation, he has to regularly consult with the various departments of the Department of Justice because he's not imaginary. He's real. And this is what you have to do when you have a boss and you're employed and you have to consult as required. So the whole thing just always brings us back to Judge Cannon. As you properly pointed out, a judge in California looked at Hunter Biden and said, yeah, no, that's the only judge in the world that's ever made that ruling. And I don't agree with that ruling. And that is about the special counsel, especially in this case. Will that create a split in the circuits ultimately? Will like the 9th Circuit somehow be different than the future 11th Circuit? Because we left out something in September. There's briefing. See, I knew we left out something. There's briefing that's going on at the 11th Circuit about Judge Cannon's decision that's going to happen. September is going to be a very treacherous and dangerous month for Donald Trump, candidate Trump, felon Trump, defendant Trump, and trying to keep that all straight.
So, Michael Popok, just to reinforce this point to viewers, anytime a Republican or a MAGA gives you the weaponization talking point, go, okay, so explain weaponization. Donald Trump appoints judge dismisses case against Donald Trump because she says that special counsels don't exist. The DOJ under Biden charges his son, Hunter Biden. Hunter Biden makes argument. Trump says special counsels don't exist. Judge Cannon dismissed case. Can I get that same treatment? If special counsels don't exist for him, don't exist for me. That federal judge goes, nope, that's just for Trump. Okay, well, that doesn't make much sense to me. Call me. Perhaps I'm just confused here, but that doesn't make any sense to me.
Welcome back. Lawyers talking about things they know what they're talking about at the intersection of law and politics. That is refreshing. We invite you to join us Wednesdays and Saturdays at 8 p.m. Eastern Time, where you can watch us live record Legal AF and chat. You can live chat with the actual anchors. Wednesdays, I do it with Karen Freeman, Nick Nifolo. Saturdays with Ben Meiselas. Hot takes like this about every hour. If you're old school like me and you like to listen to your podcast, you can just plug in Legal AF and you'll pick up our podcast anywhere you get your podcast from. So until my next Legal AF, until my next hot take, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.